Chief Tracy, how are you?
Very good. Very good.
Good. Thank you for coming in today. I've been having a lot of conversations about a lot of different bills. So we had the Bolter-Stahl bill. We had the enhanced sentencing, which again is the enhanced sentencing. We had the felony for Johns on first try. We have the mandatory minimums for DUI, second offense when you kill somebody. We had the, again, a bunch of different things. I've had conversations recently, and again, I'm not up to speed on all of them, but I've had some conversation where I'm like, I don't think that was 100% right, but again, I don't know. So you agreed to come in to help set everything straight with a couple of these bills. Thank you for coming.
Yeah, absolutely. Thanks for having me.
Let's start off with the Fourth Amendment waiver. Now, this one in particular, and again, just a brief background, essentially, if you're a felon and you're on parole, and you get pulled over by a law enforcement officer, say it's 2 a.m., just a traffic stop, that law enforcement officer cannot do a search on you unless the parole officer is there. Now, under normal circumstances, if he has reasonable suspicion, whatever it might be, yeah, he could, whatever.
Right.
But with a felon on parole, they could search you if the parole officer is there. But in the absence of the parole officer, they can't do anything about it. This bill allows an average law enforcement officer to engage in a search in the absence of a parole officer if they're dealing with a felon on parole. Is that accurate?
Yeah. Okay. Or a felon who's on probation.
Okay.
So the way it normally works, one, you're not going to Idaho prison, I won't say ever, for a first offense, even on felonies. Okay. You really have to work to get into the prison system.
Okay.
However, there are decisions that judges make where maybe they want to put you on probation rather than sending you to prison. So they put you on felony probation. And part of that agreement is normally you give up certain rights or some of your rights. And normally it's your Fourth Amendment right to unreasonable search and seizure. Same thing happens in the parole situation where you've been in prison, you're coming up for parole, and they parole you out into the public. You agree to give up your Fourth Amendment rights. And that does a few things for us. Number one, it helps become a force multiplier for probation and parole. Number two, it helps us make sure that you are being held accountable as a parolee or a felony probationer, that you're being held accountable while you're out there, which really we all know if we want to be successful, we need people to hold us accountable. It's the same way with our kids, but you've made this agreement. So rather than going to prison or rather than remaining in prison, you are going to show us that you can get out, you can be with your family, you can work, you can keep a job, and you can show us that you are going to be successful under these circumstances. And our way to make sure that you are following those rules is through the Fourth Amendment waiver. This was a really big push by the Idaho Chiefs of Police Association this year, along with the Idaho Prosecuting Attorneys Association, Fraternal Order of Police, and the Idaho Sheriff's Association. Our current chief of the Chiefs Association, Rex Ingram, really spearheaded this and was the one that really wanted to drive this through the legislature, and we were able to do that successfully. But I've heard on one of your podcasts some misrepresentation of how this works. Number one, people on misdemeanor parole do not fall under this bill. It is very clearly written in the bill that it is for felony probationers.
Okay. So if it's a low-level crime, I do not waive my Fourth Amendment.
Exactly.
Okay. That's important to know.
So what this does do, though, if we stop somebody, we realize that they're on felony parole or felony probation, only kind of parole is felony, then we have the right to search their person, search their belongings, search their vehicle. If we're at their house, we are able to search their residence. However, one of the misnomers is, well, what if my son is living with me? Then you get to search all of my things. That's not true. We get to search where your son resides, so their room, and where they have access to, so community access. So
like
the living room, the kitchen,
Gotcha.
Those types of things. We don't get to go into your bedroom as the parent. We don't get to go into the other siblings' rooms unless perhaps he was sharing a room with a sibling. So there are definite parameters around that. The Supreme Court has reviewed this law previously, and they've ruled that it is constitutional, that those people have made an agreement, right? So what they did is they violated the social contract that we all hold with society, and they went and violated somebody else's rights. And as a result of that, they are losing some of their rights for a period of time. Once they've completed their probation, once they've completed their parole, they're free and clear. They don't have to worry about this anymore. They no longer have a Fourth Amendment waiver, and they can go about their business.
Okay. That's a completely different picture than what I've heard in the past. And again, I've heard a couple different, I spoke with Representative Schertz about this, and then Representative Rubel. And again, you bringing this to light in this way. All right. So bottom line is, it's for a specific period of time. If I'm living with somebody who's a felon and I'm living in a room adjacent to them, the search and seizure is not coming into my bedroom. It's only coming into our shared areas.
Correct.
Bathroom, kitchen, living room. Fine. You can check my toothbrush, whatever you want. Okay. And again, it's something that exists right now. It's not like we're inventing this fourth waiver. It's no, you can engage in this type of search and seizure just in the absence of this parole officer. But if the parole officer was there, you'd have the right anyway. It's not like something new is happening. It's just taking out that piece.
Exactly. And I know one of the examples was, your house is going to get raided at 3:00 in the morning. Well, that's one, not practical. Two, it's not a raid. It's usually a couple of officers who've come into contact with you that are conducting this search of your residence. And three, really, if we have a legal reason to be at your residence, somebody called in a noise complaint, and we go and we're investigating the noise complaint, and now we realize that you are on felony parole, then we're going to do that search. We're not going to replace probation and parole. We're not going around to do compliance checks, so to speak, for probation and parole. It's if we come into contact with you in a legal reason, legal purpose.
When you said it's not practical, this is one thing that I was wondering about, because again, it was said in a previous episode that, hey, look, they're gonna be going after anybody for any reason. That just doesn't seem like it would be an efficient use of manpower. Right. Like you're not just wandering around just because. I mean, like you have a job to do. You only have a certain amount of funding. You only have a certain number of officers, working the streets. Like you guys likely aren't going to go. And again, the parole department is something different, right? Like if you're a parole officer and you're doing checks and things, okay, fine. But you as let's say chief of Meridian PD, you're not just going to start telling people to go do these things. It's like, no. You're only doing that if you have a real specific reason.
Exactly. If we've come in contact with you through the course of our regular work, then we may conduct that search.
Gotcha.
We won't be violating people on their parole or their probation. That's not our job. We'll notify probation and parole of the violations that we've uncovered, and it's their decision to decide whether or not they want to violate somebody's parole or their probation. The other thing about that part of it is, but if you've committed a new crime, can you be arrested for that new crime? Absolutely. If I come into contact with you, I search your person and you have methamphetamine on you, yes, I am going to arrest you for possession of methamphetamine. On the flip side of that, if we conduct a search, you've been completely cooperative with us, we will report that to the probation officer or parole officer as well, which bodes well for you as somebody who's on parole or who's on probation. Especially in the case of probation, you may get off of probation early because you've had several interactions with police, you've always been cooperative, and we've never found you in violation of your probation. So you could actually petition the court to get off of probation early because you've shown a propensity to follow the rules.
That's great. I had never thought about that angle, but that makes perfect sense. It's like, look, I've interacted 6 times, every time at random times that were not my choosing. Everything was fine. How about you let me go?
Exactly. And you have to understand, we as police officers, we want you to be successful. We want less people violating the law.
Please stop doing bad things.
Yeah, exactly.
Gotcha.
We want you to be successful. And this is a way when somebody realizes, you know what, I could come into contact with a police officer and they can search me because I gave up this right. Mm-hmm. or limited this right because I want to be out in society and prove that I can be successful. This is that little bit of a nudge sometimes that somebody needs to know this is where I can go and I can prove that I am doing things right. And I'm not in possession of contraband. I'm not committing new crimes. I'm not doing any of those things.
Gotcha. Okay. Couple more I want to ask you about. And again, did we cover that one?
We did. I think we covered it pretty well.
Right. Mandatory minimums for second DUI when you kill somebody. Let's start with this one. Now, even in the state of Idaho right now, currently, right, even before this law came into effect, if I had a DUI and I killed somebody on the first offense. So I saw a film about this called Shot Caller recently. It was wild. This guy kills somebody, was out with his, friend and his wife, and his friend dies in the backseat. They had too much wine. He blows like a 0.1 or something. In the state of Idaho, there's no mandatory minimum for that.
Right.
So it's like, even if someone dies in the interaction and you were wholly intoxicated, there's no mandatory minimum for like, you're going to go to prison for it. And this bill doesn't even affect the first offense. So you can kill somebody on the first offense. We're only talking about if someone dies and it's your second DUI, then we get a mandatory minimum. Talk to me about this one.
Yeah. Well, a couple of phases to this bill that I really liked. One, it has an educational phase in it, and two, it has a deterrent phase in it, and then three, it has the punishment phase in it. And I say that because on your first DUI under this code, a judge would be required to notify you that if you have another DUI and you're involved in a crash and you kill somebody, this is what you will be facing. So you've educated them. Hopefully it's working as a deterrent because, if I'm out drinking and driving again and I kill somebody, I am going to be in prison for this mandatory amount of time, period. So I think it's a very effective law, very well written. It's one of those laws that really encompasses everything in it, as well as, requiring the judges to inform the defendant of what they could face if they continue this type of behavior.
Okay, two questions. One, this law only comes into effect in the event of loss of life, correct?
Yep.
Okay. And two, what the argument that I've heard against mandatory minimums is that we need to give judge discretion, right? We need to allow judges to figure out what's best. What is the judge discretion that people feel would be appropriate or has been argued for in this situation? I understand if you're talking like drugs or something, but it's like somebody has died.
Yeah.
Right. And it was not your first offense, your second offense with drunk driving. Like, we have actual loss of life. And the mandatory minimum is, I think, 5 years. Is that correct?
I believe so, yes.
Okay. So what's the argument for like, no, this person killed somebody and they should only get 3 years or something like that?
Well, I think the argument is, and I think we see it a lot in society, we are misplacing our empathy. We are putting our empathy on people who are engaged in criminal conduct rather than putting that empathy where it belongs, on the victims, on the victims' families. And so I think that some people have skewed their view of who really is being affected by these laws. Young lady that I used to work with, who this bill really was kind of pushed on her behalf. Her husband and father-in-law were killed by a multiple-time offender drunk driver in a car accident up north. That offender had been let out of jail. And even with deaths, oftentimes we will see a judge who places their empathy in the wrong place and places it with the defendant, right? Oh, the defendant has a family. The defendant has a good job. But what about the family who just lost their loved one because of that defendant's behavior? And we miss that oftentimes, I think, in our system. It's one of the things I think that Truth in Sentencing in Idaho is really good at recognizing is if we tell you you're going to prison for this possibility amount of time, you're going to go to prison for that amount of time. And so the victims' families have some closure and they realize that, and they're not going through these negotiations over and over trying to reduce the sentence and doing those types of things. If it doesn't meet the code, a judge's discretion is throw the case out on any of these mandatory minimums. If you believe that the evidence that we presented before you in a preliminary hearing does not support the charges there, you have the ability to reduce the charges. You have the ability to throw those charges out.
So the judge has to participate. Then they have discretion. They have to participate even to get to the point of the mandatory minimum.
Yeah, absolutely. The judge can look at the preliminary hearing and say, yeah, I don't think you've met the threshold for a mandatory minimum of drug trafficking or of the DUI manslaughter. I think this really, though, narrows it down and says, yeah, but if you do these things, if it's very clear you do these and you are found guilty, you're not just charged, then here's the punishment that you are absolutely going, at a minimum, going to face.
Man, that's a tough one to swallow. That is tough to imagine that people are fighting against that. And again, I'm not a law enforcement person. I don't deal with prosecution, but just as you're pointing out, from a citizen standpoint, it's like, if I get killed, by some multiple time drunk driver, I would want my family to feel like they got justice. Anyway.
In spite of all the people, too, when we talk about minimum mandatories for drug sentences, when we talked about that for fentanyl, we got that passed through last year, and we just had crazy arguments about it. The number of people that are overdosing because of fentanyl is it truly is an epidemic, really, in this country. And so we really pushed, let's hold those traffickers accountable for that. And we had people who came up with crazy things like, oh, well, what if they took and threw the fentanyl in a bathtub full of water? Then you could take the weight of the water and you're getting... Really? In what world would that happen?
Right.
And in what world do you think that we would charge somebody with trafficking because they threw the fentanyl in water, or they threw it in their pop can, but they hear these crazy stories of the first time somebody got picked up and it was personal use and they got sent to prison on a mandatory minimum. We've proven those stories wrong. They've brought people in that have testified, claiming that occurred, and we literally have brought the case information forward and said, no, this actually isn't what occurred. Here's what actually occurred in this case. And they were a drug dealer. One of them was... that testified not this year or last year, but the year before. They came in and claimed that this poor person just was a user, wasn't dealing drugs, and we were able to bring the case agent in who came in and said, well, no, actually they had runners that were running heroin for them, that were running fentanyl for them, and their dealer, who was in Salt Lake, Utah, refused to come to Idaho because they had already served time on a mandatory minimum sentence in Idaho. And if they get caught with the same amount of drugs or again for that trafficking, then their sentence doubles under the law. And so we have people on wiretaps in some of these drug cases literally telling people, you can meet me at the border, but I am not coming into Idaho because I know that they have mandatory minimum sentencing.
Okay, question for you. Don't we have federally deputized law enforcement agents that can go into Utah or into like Oregon and engage in those deals?
We do, but there is a threshold before the feds will take one of those cases.
Gotcha.
And they wouldn't be facing a mandatory minimum in Idaho.
Gotcha. Okay, so it's a different thing.
Different thing. But
Gotcha.
if they were if say our DEA task force was working this specific case, they would use the drug transaction that was used in, say, Oregon.
Well, sure.
And they would use that as part of their case in federal court for an enhanced sentencing through federal court on the amount of drugs that they've been dealing.
Gotcha. So the Idaho mandatories don't apply
exactly.
to those. Gotcha. And the mandatory minimum for fentanyl in particular, I had several conversations with Representative Hill last year, and it was painfully obvious that he's like, we are not going after individual users. Like, we have people dying, like it seems like the number of people that have personal experience with somebody, either somebody unintentionally consuming fentanyl or somebody, getting an inappropriate dose. I mean, just like the horrible stuff that it's doing to our country is just really substantial and needs to be addressed. And again, these laws are addressing dealers, people who are engaged in commerce of poisoning our population.
Every one of our mandatory minimums, when you look at the amounts on them, tells you, if you get caught with this amount, you're a drug dealer, right? Our lowest threshold for trafficking, when we'll use marijuana as an example, is 1 pound, but less than 5 pounds, or 25 plants or more, but less than 50 plants. That's our very bottom threshold. If you're caught with that, it's a mandatory minimum of 1 year in jail. Even Cheech and Chong aren't walking around with a pound of marijuana on them for personal use. So this idea that we're going after people that are addicts and they're just using for personal use is it's such a disingenuous argument when you look at the amounts of drugs that they're bringing into our state, that it frustrates me even to hear it. And we had heard it on the floor. Oh, these poor college kids, they went to Washington and got some marijuana, and they were bringing it all back to bringing enough back to supply the frat house, their friends at the frat house. And they got hit with this small amount for mandatory minimum of marijuana. Well, no, if you're supplying a frat house with copious amounts of marijuana, it's not personal use. It is definitely going to be a large amount. And we're able to prove that and show that.
Right. That admission of distribution intent is not a good thing to say. It's like, no, it was just for me and 40 of my best friends.
Exactly.
Like, don't say that. That's not just say you're a rampant user, like anything but that, because you just obviously that's the definition of distribution.
Yeah, exactly.
That's a rough one. Okay. Last one, the death penalty for child molesters. Now, this is not a Romeo and Juliet situation where you have, say, like a senior in high school dating a sophomore and they happen to be having sex and then the senior turns 18. Right. This is not what we're talking about. We are talking about people 12 years or younger being violently assaulted by an older person.
Exactly.
Talk to me about this.
Again, it goes back to where are we placing the empathy? I would like to see us start passing more laws to focus on the victims of these types of crimes than trying to fight laws protecting the perpetrators. I'm not sure that there is any crime that is more heinous, more disgusting than the molestation or the rape of anybody, but as children under 12. And there are aggravating circumstances within that code as well that they put in there so that they believe that it will stand up to the test of time if it goes to the court system. We're not the first state to pass this law. Florida has a similar law. Texas has a similar law, and they're making their way through the courts now. So we'll find out if it stands up. But again, I shake my head at why would you oppose this type of a law that it doesn't mean it's a mandatory death sentence. It just says the death sentence is on the table. I remember years ago, there was a former Boise police officer who family had a daycare and had molested and raped multiple kids. Don't you think that person should really be held accountable? Don't you think that is truly probably the worst of the worst type of criminal that we could ever come into contact with? So don't you think that the possibility of death should be on the table? Now, if you're against death penalty because of your views overall on death penalty, I totally get it, and I'm not arguing that. I would probably say I'm not the most pro-death penalty person in the world, but I can tell you if there's somebody that probably needs to have that option on the table, it's child molesters. Okay,
couple things here. So this bill offers discretion for the court, right? So again, it's not a mandatory capital punishment. That's important to know. And second, there are tiers of, like, you have lewd and indecent exposure, right? So like say, well, now the new rules around, let's say the Nampa Pride Festival, right? You have two men that come and they have, augmented top surgery to have female looking breasts. Okay. That would be lewd and indecent now that, the bill has been passed that says, hey, that's the deal. Those are not people that would be on the table for that. Like there are tiers of impropriety. There's, and this
indecent exposure is a misdemeanor.
Right. So we're talking about people that are committing absolutely reprehensible acts against young, innocent people.
I would say the worst of the worst acts that could be committed against a young person.
And again, aside from the pushback from people that categorically are against death penalty, okay, totally fine. For the people that do believe there should be a death penalty in our penal code, but are against it for this particular crime, what is the argument for that?
I could not give you an argument for that. I think that really the people that you have people that are really, again, I say putting their empathy in the wrong places and really focus on what is happening to the suspects in these cases and many other cases, rather than what are the consequences for the children that are involved in this type of a case. And I think we see that a lot across the board, that rather than focusing on what is occurring to these victims and how are we going to get them to recover and be productive in society, we're focused on, oh, we need to make sure this person doesn't go to prison too long because they, quote unquote, they could be the most productive drug dealer I've ever met in my life, right? They're the one-time drug dealer, which I've never met a first-time drug dealer, just for the record.
One thing that I did hear, I can't remember who articulated it, but one thing I did hear is somebody cautioned, I think it was Ron Nate from the IFF. He cautioned, he said, look, if you have the death penalty on the table for this person, as it stands right now, they say this person is terrible against a 10-year-old, does terrible things. That person, the burden that they have is like, okay, don't get caught. So they put a lot of pressure on, say, the victim, which is absolutely terrible. And that's their risk analysis, which is like, I have to convince this person not to do something. And if they do, then I will get a certain amount of time in jail. And he was saying, look, if you make that worse so that the guy knows, hey, if this kid talks, then I potentially could be getting killed, then there would be an incentivization to actually not just guilt the victim into not saying anything, but in fact, terminate the victim, like kill the victim as well.
Sure.
Is that a type of analysis that has played out in other places in the legal system or in law enforcement?
We haven't seen that anywhere else.
Okay.
And what I would say is, and I understand that point of view, but I would say it's very similar though to when I was working undercover and people used to say, well, aren't you afraid they're going to find out you're a cop? No. Really, for the most part, no, because most of those drug dealers, no matter how high they are up in the organized, once they find out you're a cop, they're going to leave me alone because they know that if to kill me, right, the law's coming after you, full both barrels, right? They're going to come at you that much harder and bring that much more pressure onto your organization and all of those things. And so I would say the same thing here. The death penalty may be on the table, but if you kill someone, you know the death penalty's on the table. So I don't think that people go, oh, well, I'm going to do this because they may speak. You kill someone, your chances of getting caught are much greater than them just keeping their mouth shut.
That's great to hear. I had not conceptualized that, which is essentially if you're doing some kind of cost benefit analysis as this terrible person and you're like, well, I can't let this get talk. It's like, well, if you're afraid of this end, if you're afraid of the capital punishment, you're going to have a much higher likelihood of getting that if you do this horrible act and then you kill the person as well. Like, so that would in itself be a deterrent.
Absolutely. And you're more likely to get caught if you take somebody's life. Because those investigations, right, are those are the ones that police, they want to go out and they want to catch whoever perpetrated that crime. It just has such a high level of trying to bring some closure to the family and make sure that we're getting the worst of the worst off of the street. And so I don't foresee anybody looking at it that way and going, well, I'll just kill them instead.
Gotcha.
They're still going to take their chances of they just won't talk.
Look, man, we hit 3 big ones. There have been a lot of law enforcement bills come around this session, including again the enhanced sentencing, and then a lot of discussion around immigration enforcement and whatnot. Is there anything else you'd like to hit today?
The only thing I would like to say is, we were called communists when we were trying to pass the Bolter-Stahl bill. So I would say this: we are not communists. The police in your state are not communists. We were just trying to get a larger sentence for somebody if they were to kill a law enforcement officer. And the point that I made to the committee in the House was, I believe it was Plato said that if the masons and the cobblers failed to do their job well, we're going to be just fine. But if the guardians fail to do their job, it'll be the end of our republic, the end of democracy. And so I think what some of those legislatures don't realize is when they pass those laws and they do those things, we're the ones that have to uphold those. We're the ones that have to carry out their will through what they do. And when you attack a police officer, I believe that is an actual attack on the entire country, the entire government. It is an attack against our republic. And I just wish some of them would have listened a little bit closer. But they didn't, and we'll come back next year and we'll run a bill that hopefully gives them more of an appetite to go that route. Our job really with the police and the sheriffs and the prosecutors associations, we really want to keep Idaho safe. And that's what we're doing. And when people complain about we have a high number of people incarcerated in the state of Idaho, we also have an extremely low crime rate compared to other states around us and other states that have gone away from what we're doing. And I would say the proof's in the pudding. We're putting the right people in prison, which is helping drive that crime rate down.
When, if I may ask, when you're talking about the incarceration rate, so you're saying, hey, look, yeah, we are housing per capita more people than, say, the West Coast states. But we also have fewer instances of crime than the West Coast states. So essentially, the idea would be if the West Coast states got on board with this, they would increase their incarceration rate, but they would also grab the repeat criminals, and that would improve everything. That's essentially the model Idaho has.
Yep, that's part of the argument for sure.
I didn't know that. I had heard that Idaho has high rates of incarceration, and I did not know that it's inversely proportional, at least in this case, to the actual crime rates of the state.
Yep.
That's great to know. That's great to know. Well, Chief,
awesome.
Thank you for coming in today.
Thank you.
I appreciate you. Thank you for explaining this stuff. Obviously, a bit of a sobering conversation, but important, especially considering the legislation that got passed. So thank you for coming in. As always, let's do it again.
Great. Thank you.